Am I connected? Just confirming, please. My lord, it's such a pleasure. Namaskar.
Namaskar. Good morning.
Very good morning, sir. How have you been, sir?
I'm fine, sir. Good. Thank you.
I have not had the pleasure of meeting you before, but I surely hope that I would rectify the wrong that has been committed.
Mr. Kapil.
Yes, sir.
Kapil Sankhla.
Yes, sir. My name
Yes.
is Kapil Sankhla.
Okay.
We've been doing this for 3 years now. And
Okay.
I otherwise, as a lawyer, I practice predominantly High Court and Supreme Court. I also teach in NLU Delhi
Okay.
and RGNLU and some other faculties, some other colleges.
Good. Good.
Predominantly on the criminal side, and appellate side, of course.
That's very nice.
This Rupam had started during lockdown, and we found it a great way to ensure that the youngsters and the younger members are kept busy, and also it became a great way to teach and interact with youngsters. and it's
Yes.
grown by leaps and bounds over the uh, short span of 3 years.
No, it's a great job you are doing.
Thank you, thank you. Mahendra. Are you in Delhi as of now, or in
I'm
Uttar,
no, I'm staying at Lucknow.
staying at Lucknow itself?
Yeah.
Good morning, everyone, esteemed participants and distinguished guests. I'm Shomili Kundu, and it is my privilege to be your host for today's momentous occasion. On behalf of the entire team at the Amicus Curiae, I extend a warm welcome to each of you to the inaugural session of the third edition of the Sankhla Associates National Virtual Moot Court Competition 2024. We are delighted to collaborate with our esteemed joint organizer, Sankhla Associates, to bring this prestigious event to life. Allow me to briefly introduce the Amicus Curiae. Conceived by a consortium of leading legal scholars and renowned professionals from both India and abroad, the Amicus Curiae represents a visionary online platform dedicated to advancing legal knowledge. Our mission is to disseminate comprehensive legal insights and foster a deeper understanding across various legal domains, ensuring that our resources reach every corner of the ever expanding legal community. With a focus on contemporary legal challenges and ongoing developments, TAQ contributes significantly to the discourse in the legal field. We are registered under the Indian Partnership Act of 1932 and the Ministry of MSME, Government of India, and proudly stand as the eighth largest legal website in India, connecting over 20,000 law students from more than 80 law schools across the country. It is my distinct honor to now introduce our joint organizer for this competition, Sankhla Associates. This distinguished law firm offers a comprehensive range of legal services with both national and international reach. Sankhla Associates collaborates with top solicitors from Singapore, the United Kingdom, and India, providing tailored legal solutions to individuals, firms, and organizations. Their expertise spans insurance law, bankruptcy law, debt management, corporate law, advisory, and insolvency and bankruptcy laws, among others. With a reputation for excellence and a commitment to the highest standards of legal practice, and Sanklan Associates shares our vision for promoting legal expertise and professional development through these competitions. Now, I'd request one of our team members at the Amicus Curiae to kindly play a short video on our event smooth proposition. Thank you.
Republic of Hindustan is a country in Southwest Asia, the world's largest democracy and known for its powerful government. It is a developing country where freedom to practice any profession or carry on any occupation, trade, or business is given to its citizens. On 11th of September 2013, during patrolling duty, Complainant Assistant Sub-Inspector Naruto arrived in front of Shalimar Metro Station Gate Number 2 in the state of Rajasthan, where he received secret information that sex toys were being sold in shop number 16 of Shalini Bazaar. He reached the spot and on searching the shop premises, an orange-colored sex toy and a purple-colored battery were recovered. Mr. Obita Roy has committed an offence under Section 292 of IPC. FIR was registered. The case went on trial. The trial court held that in cases of this nature, the court, while considering diverse perspectives, would base the evaluation on an objective set of criteria, not on individual interpretations. 10 minutes after, he decided to open a sex toy shop in state of Beach Town. Mr. Obituray was under the impression that his right to freedom of trade and business would not be violated in this state. In 2023, Hindustan's first sex toy shop was being opened in Beach Town on the occasion of Valentine's Day. A month later, the shop needed to close its shutter because the Sarpanch, Mr. Nagarjun there, said that day had received verbal complaints from many people about the shop and that it was against their culture. There were several other instances where selling of sex toys in different states of Hindustan were vandalized, shut down, and shop owners were punished and removed. However, Mr. Obito Roy found out that the recent trend showed the rise in demand and usage of sex toys among people. In the last few years, the e-commerce market for adult or sex toys has experienced a boom due to a wide variety of sex products being made available. The global market for sex toys was estimated at $25.1 billion. The Constitution of Hindustan provides certain fundamental rights, one of which is the freedom to practice any profession or to carry out any occupation, trade, or business under Article G of its Constitution. Under these four circumstances, Mr. Obidor decided to file a writ petition before the Supreme.
Thank you so much for playing the video. Now I'd like to introduce Mr. Kapil Sankhla, our distinguished patron-in-chief. Mr. Kapil Sankhla, who established Sankhla Associates approximately 20 years ago, is the company's managing partner at the moment. He has been practicing ever since 1999 and received the coveted 2016 Super Lawyer of the Year. His background includes a wide range of topics related to the disputes corporate and legal advice, litigation and arbitration business-related issues, white-collar offences, employment, infrastructure and public policy issues, ethics and policy are all related. He has been recognized as one of the top attorneys in India, occasionally appears in several media. Now, I'm delighted to invite Kapil sir to share a few words with us. Let's give a virtual round of applause and welcome him to the screen. Over to you, sir.
Thank you. Thank you for that lovely introduction. I have been a lawyer for now more than 25 years. And at this stage, it just feels very happy that I'm giving back whatever knowledge and whatever experience that I've accumulated. But first, it gives me immense pleasure and honor to welcome our chief guest, Honorable Justice Mahendra Dayal, former Judge Allahabad High Court, guest of honor Mr. Sanjoy Ghose, Senior Advocate, Supreme Court of India, guest of honor Mr. Abhinav Mishra, co-founder of Chambers of Abhinav Mishra panel, who's the panel counsel of Union of India in the Supreme Court. I've had the pleasure of going through judgments by Justice Dayal, and incidentally, in one of the matters that I was doing. And just to digress, but it is a judgment that all you youngsters should also read. If I'm not mistaken, sir, it's Uttai versus State, if I'm not mistaken, where my lord had upheld the death penalty and distinguishing between, somebody who is not a hardened criminal, but the act of the person being of such a nature deserves the kind of punishment. Justice Dayal graduated with a degree in law from Allahabad University in 1978, and he has had a brilliant judicial career. And as I said, that of all the great judgments that I've read, Uttai is one of my favorite. Guest of honor, Mr. Sanjay Ghose, we welcome you here. Mr. Ghose is Senior Advocate of the Supreme Court of India and also in Delhi High Court. I've had the pleasure of meeting him innumerable occasions. He's recognized for his expertise in constitutional law, civil liberties, and criminal justice laws. He is an advocate for judicial transparency and has raised concerns many times about potential misuse of new laws, especially impacting the marginalized communities. So therefore, I'm sure Article 19 is very, very dear to him, and he would be a great asset to the youngsters when he gets to talk. To the guest of honor, Mr. Abhinav Mishra, the co-founder of Chambers of Abhinav Mishra. He's an experienced lawyer. Again, I've had the pleasure of meeting him. His expertise, if I'm not mistaken, is on the corporate commercial side as also on the criminal side, which is very interesting because a lot of now corporate lawyers also have become criminal lawyers because criminal law and commercial law has intermingled so much in today's date with these specialized acts, etc. And so he specializes, to the best of my knowledge, in banking, finance, and taxation laws. He's been a legal advisor to the government, corporations, many public sector banks, startups, served as panel counsel for state-owned PSUs. And in 2018, he founded the Chambers of Abhinav Mishra, known for handling, as I said, corporate litigation, spanning civil and criminal arena, and of course insolvency matters, while promoting legal education through various webinars and workshops. That I extend my warm and heartfelt welcome to each one of you. Today, as we come together for the third edition of this event, we are truly privileged to have representations from more than 70 dedicated and enthusiastic teams from all corners of the country. Amicus is very close to my heart, more because, deep inside during lockdown, I realized that there was an educationist in me. And this was the only time when I get to talk extensively, not just in court, but out of court. And when Rupam had contacted me, I thought that this was a wonderful thing. He was one of the first to think of doing something online. And this became, and I think perhaps it still is one of the biggest, the largest moot court competitions in India virtually. Coming to Article 19, for which this moot court is all about, it's a very interesting phenomena. You see, at one stage we go one way towards how US looks at your rights and say they have to be absolute, while the Constitution does put certain checks on those absolute rights of yours. Recently, I was hearing an argument in the Honorable Supreme Court which pertained to people in Bangladesh who have settled in India, more towards Assam. And the argument was that they have an absolute right to settle anywhere. They have an absolute right to profess their religion. They have an absolute right to go wherever they want to. And I remember my Lord Justice Chandrachud saying, yes, but this is only for the citizens of India and not for others. And the argument on the other side was that, yes, but before independence, it was all part of India. You cannot take that. So a very interesting argument that was being done. But Article 19 seems to be in the middle of everything which is interesting when it goes on. For example, whether cigarettes can be shown being smoked on in a movie pertains to an argument under Article 19. How thick can a newspaper be is a part of Article 19. Your right to information, which is perhaps one of the strongest things this democracy has given the citizens of India, is all a part of Article 19. Justice Bhagwati in Menaka Gandhi had underlined the importance of free speech, saying that a democratic society stands fundamentally upon unfettered debate, discussion, and open dialogue, as it acts as a sole corrective of the government action, keeping in view the democratic settings. Considering that democracy is the rule of the people, by the people, and importantly for the people, it is self-evident that each and every citizen is authorized to have a right to partake in the process concerning the democratic functioning, and that unfettered and open debate of issues concerning general policy is vitally essential to allow him to exercise his right to vote wisely. Now I stop here for a second, and I stop here because we have the blessings of my lords here and an eminent senior counsel. The question here for my lords perhaps to elucidate us and enlighten us would be that when you have the freedom of speech and you call that, if not absolute, but unfettered, and at the same time, what happens to an issue perhaps pertaining to contempt, where the contempt could be perhaps be on a fair understanding of a situation in the court, because as we all know, that the only defense you have is an unconditional apology, perhaps on a practical level, though theoretically you also say that truth is the best defense. But that is something that I would love if we could have some discussion on. And it is perhaps my privilege to speak on one of the cornerstones of our democracy, the fundamental right under Article 19, Part 3. Now, interestingly, the concept of free speech pre and post independence in India and also across the shores has been something that has been debated upon, has been fought tooth and nail. As I said, at one end we have the US that thinks that the right is absolute. Then we have our constitution, which has certain checks on the right to speech. And then there are certain neighboring countries where there is no concept of free speech. Every speech perhaps is tested by the government and controlled by the government. But the notion of free speech is said to have begun in the late 5th or 6th century BC. Freedom of speech and religion were two of the Roman public's core ideals. Interestingly, the right to free speech are also a part of our ancient stories on what is the right of a person to say and to question the gods. I was reading a story about the Rishi and Muni debating on the role, on the right of Brahma to get married or to Ma Saraswati. And it was a very interesting story where there was one side that stated that you cannot question gods, and the Rishi and the Muni said, no, it is only through debate. The lines from Justice Oliver Wendell in an argument as recently as last month expressed a dissent claiming that free speech has always been a never-ending endeavor. It is closely linked to democracy. Freedom of expression is the fundamental characteristic of the United States Constitution, according to the First Amendment. So, right to freely express and propagate one's opinion is a claim against the state policies that began in England under common law precedents, which also, of course, where we derive our laws. The freedom of press is one of the greatest embarkment of the civil autonomy, and it can on no account be curtailed at the hands of a dictatorial government, according to Section 12 of the Virginia Bill of Rights of 1776, perhaps. As per Article 19 of UDHR, everyone is endowed with the right to free expression, and this right includes freedom to hold opinions without restrictions and to access, acquire, and import knowledge and opinions through channels of media and regardless of boundaries. Now, if we stop here for a moment and we say whether the channels of media have an absolute right or those rights are fettered by special statutes, special rights, interpretations, etc. Because there is a fight going on as we speak on an absolute right of a channel or a media house to give, and I'm going to use this word very carefully, if not news, then their views, and the government right or the judiciary right to control the dissemination of information. And as I said, because there is hardly any news here, there's mostly views. And then the question would be, do the channels also have a right to go beyond the boundaries, because we do live in a digital world? It's very interesting, again, if we also talk about contempt and this point, as I've just elucidated, on the courts now being streamed virtually in everybody's house. And we do see a lot of memes, a lot of disconnected parts which come out from the thus spake, my lords, as to say. But I'm very happy to say the Delhi High Court has started something called humor in courtroom. And so I think our sense of humor has also getting developed, and we are coming back to that era where we could see a great repertoire between the bar and the bench, and also perhaps between two lawyers. Now, since 1950, the Supreme Court interpreted free expression as well as the equality clause and the protection of life and liberty with sufficient volition. It has been referred to a fundamental human right, a natural right in other terms. But please do remember that that right is has its own checks given in the Constitution and through various judgments. Coming back to the right to smoke a cigarette on a channel or on camera in movies was tested in Mahesh Bhatt versus Union of India, where it was held that free speech is one of the foundations of Indian Constitution, and that upholds it. The right to free speech and expression is a crucial component of a democratic framework, and in order to maintain a functioning democracy, citizens must be informed and educated. So now we do have is that we have the hero of the villain with a ticker underneath saying that it is not good for health. It is worth noting that the scope of the right to free speech as per Article 1A has been broadened to encompass the right to receive and transmit information, because the question was that you may receive and you can have the information, but can you transmit it, was tested in Uttar Pradesh versus Raj Narayan. The Supreme Court concluded that Article 1A of the Constitution bestows upon every citizen the right to indulge in free speech, as well as the right to receive and spread information on topics of public importance. Now, public importance and what is a state has also been tested in various judgments. Freedom to collect and communicate information is included in Article 19(1)(a) of the Constitution of India. According to his views, that without open political deliberation. Now, for example, when we talk about RTI, a lot of work behind the scenes is being done to kind of fetter, to control what the powers under RTI for a common citizen is. CBI has already been taken out, so have various other organizations, and it makes me wonder, why do we have to hide something when RTI, freedom to speech, is an integral part of any democratic setup? So the issues of misuse of these rights might arise from the bestowal of such enormous freedom. However, the framers of the Constitution may well have agreed with Madison, and this is important, who was the driving force behind the First Amendment's drafting, who believed, and to quote him, that it is better to leave in some demerits in the concept than take away all the merits of the same, only to ensure that the demerits do not reflect. Now, as far as the international, and I would just request the MC just to give me a 5 minutes heads up when my time is getting over. I don't want to go on unnecessarily. The right to, I have some time, or shall we conclude? I just wanted to know that.
No, sir.
We have some time?
So yes, sir, you can continue.
All right, thank you. So now, not just in India, as I said, this has been tested internationally in various courts, various countries. So right of speech is also specified under the ICCPR as freedom to seek, receive, transmit thoughts and knowledge of all kinds, independent of frontiers, verbally, in writing, in print, as an art piece, or via any other media of one's choosing. This safeguards all kinds of communication, including various means, may it be written, spoken, or sign language, as well as non-verbal expression of such artwork. Additional rights cannot be exercised in society if free speech is not available. The right to free speech is also recognized by international, national, and regional rules. Article 13 of the American Convention of Human Rights, Article 19 of International Covenant on Civil and Political Rights, Article 9 of the African Charter on Human Rights, Human and People's Rights, and Article 10 of the European Convention of Human Rights recognize the existence of this right. Unlike United States of America's Constitution, India's Constitution does not directly mention press freedom in Article 19(1)(a). Nonetheless, it has been held that press freedom is included in the freedom of speech and expression. There are no special rights granted to the press that are not also granted to or asserted by individuals in his private capacity. And that is why you also have a concept which is now very popular in India, which is called private journalism. Because when you have a right that you can talk about an issue, you can collect information, you can then transmit that information, and in a digital world, it's getting easier by the day, if not by the hours. There is also something called private journalism, where you can record, express, intimate any fact which comes to your notice. This about coming back to the standard media houses, the editor or the management of a media channel are simply utilizing their rights to free speech when publicizing their opinion. And that's a very dangerous word, though. And for the same, no special rights are required just for the sake of it coming under press publication. Now, an opinion can be a personal opinion, cannot it be? And a personal opinion is usually channelized through a stream of thought. And your stream of thought has been filtered over ages by your personal experiences. somebody very wise said that the map is not the territory, which means that what you think may not be completely real. It is filtered through your senses, your understandings, and your sensibilities. So the other question that perhaps needs some thoughts to be pondered on is whether the channels are, or newspapers, etc., press is obligated to show the news, or they can show their views, which comes from their opinions. The expression, the term expression also refers to publishing, hence press freedom is covered under this category. In Prabhadat, Union of India, the right to access and acquire news and information on government management falls within the ambit of freedom of speech. However, the said right is not unlimited, and in the interest of individuals and society from whom the press acquires information, limits can surely be imposed. I remember Justice Blackstone had also made essential observations discussing the freedom of press in England in his commentary on the laws of England, highlighting its needs for a free state, yet subject to certain restrictions. I was laughing, I was talking about the size of your newspaper is also decided under Article 19. That was under the Indian Express newspaper case, where the question, the government wanted to control the size of or the number of pages in a newspaper because the paper was very expensive, it was getting imported. And the matter went to the Hon'ble Supreme Court, where the court held that a dialogue needs in a democratic country should be met by extension of specific rights, as the right to privacy, right to information, right to be informed, right to communicate, right to partake in civil interactions, and so on. The press has now begun the process of acting as a public instructor, enabling large-scale education, both formal and informal, primarily in developing countries where not all members of the society enjoy equitable access to broadcast, television, and other means of contemporary communication technologies. Now, there are certain grounds of restriction. I already said it's a part of the Constitution as well, under Article 19, also by the Honorable Supreme Court over the years, and also under certain states. For example, a great example that I suddenly remembered is that an argument was being made that in certain, I think in Northeast, certain states had banned liquor. So the question arose whether liquor can be banned. That question again was under Article 19. However, the Apex Court held that reasonable restrictions can always be put for public order, for decency, for public, etc., in the interest of public. So, as far as restrictions are concerned, only a law, not operative or departmental directive, can impose restrictions on rights under Article 19(1). Article 19(2) of the Constitution limits freedom of speech and expression by allowing the state to impose reasonable restrictions on the below-mentioned grounds that we will just talk about. Now, the interesting thing is that the state itself has been defined because there were certain attempts to control the rights of people under Article 19 by government directives, by departmental directives, etc. So one would, of course, be the sovereignty and integrity of India. The second would be the security of the state. Then there could be certain checks, which was already argued recently as far as public order, morality, or decency. And then, of course, what I was just discussing, contempt of court, and the blue-eyed boy of every politician, defamation. Then, of course, we have incitement to an offense, which again was recently argued, I think yesterday or day before yesterday, in the Honorable Supreme Court, where a gang was caught, which was basically doing forcible religious conversions, and they were getting money from abroad, and there was an argument on Article 19, and the state's argument was that this is in a way inciting the general public and inciting the people that they're converting to commit offenses, etc., etc. So the judgment, if I say, as far as the sovereignty and integrity of India is concerned, would be Devi Soron versus State of Bihar, where Article 124A and 153A of IPC was held legitimate restrictions for the sake of public order, preserved by Article 19(2) of the Constitution. We've already discussed Ramesh Thapar pertaining to the security of the state. We were talking about Israel. Now, Article 19 actually represents the soul of India's democratic ethos, embodying the value of liberty, equality, and fraternity. It empowers the individuals while recognizing the importance of collective welfare. So, to conclude, again, it is an absolute honor and privilege to be before you and to welcome such eminent, well-known, well-respected stars of our legal judicial system. Once again, I welcome all of you, every participant, the judges, Amikus, of course, for getting this all together, and our eminent guests. And I welcome all of you to this remarkable event. Let us all make sure that this third edition is remembered for its enthusiasm, integrity, collective success, and more importantly, for bringing back something to the youngsters so that they're excited about law as much as we are, despite our 25, 30, 40 years of experience at the bar. Welcome, everyone.
Thank you, Kapil sir. We are truly grateful for the opportunity to host this event in association with your eminent law firm. Your insights today have been incredibly enlightening, and we appreciate your valuable contribution. Now, I'd like to introduce Mr. Abhinav Mishra, our guest of honor, to whom we are also grateful for sponsoring our competition. Being the co-founder of the Chambers, Mr. Abhinav possesses diverse knowledge upon commercial, corporate, and criminal laws. His experience with a giant financial institution has made him competent in the banking, finance, and taxation centers. He has ably procured noted judgments from the Apex Court, NCLAT, High Courts, and NCLT benches of different jurisdictions. Presently, he is serving as a legal advisor to many Government of India corporations, public sector banks, companies, startups, resolution professionals, liquidators, etc., and is also working as the panel counsel to various state-owned PSUs and power corporations. Being a first-generation lawyer, he has always believed in making a name for oneself and has actively participated in bringing about legal awareness through various webinars, workshops, etc. Now, I'm elated to invite Abhinav sir to share a few words with us. Let's give a virtual round of applause and welcome him to the screen. Over to you, sir.
A very good morning, Honorable Mr. Justice Sir, Senior Advocate Ghose Sir, Sankhla Sir, the entire team of Amikus Qriae, the participants, my colleagues. It is with great enthusiasm that I say that mooting is an integral part of one's legal education. And if law students make use of these opportunities at the right moment, at the right time, in their inceptional stages of law learning, and if litigation or even working with an in-house or a law firm or anywhere is the sole goal, agenda in future, being analytical by observing the facts, circumstances, and the law makes us a lawyer with a lot of common sense. I am honored to be today in the August gathering where Justice Saab has been a sole inspiration along with Sanjoy Ghose Saab, watching Sanjay sir from not being a senior to being a senior and again fighting like a true warrior in the courts. It has been a matter of great learning. The Moot proposition that has been designed for this year's third edition of the Amikus Qriae Moot Court revolves around the concept of obscenity vis-a-vis the protection of speech and expression in terms of Article 19(1)(o). Sankhla Sahab has given us such a deep insight of how the entire jurisprudence around it has been revolving. I think if few people, the participants especially, have taken even a single pointer in his speech today, it is going to help them in the advanced rounds of the competition. So if I have to summarize, if I have to put it, obscenity has been defined on a number of occasions. This concept had originated from the United States, traveled to the Canadian Supreme Court, and came out as a matter of followance by the Indian Supreme Court. If we talk about the Hicklin test, though my introduction says that I am more of a corporate commercial litigation lawyer, but that is not the case. As a first generation lawyer, जो भी काम आता है हम करते जाते हैं. So ज़्यादा corporate commercial का काम आया, but criminal law has also been a matter of utter love for me. So Section 292 and 294 of the erstwhile Penal Code prosecutes an individual as an accused for committing the offense of obscenity. Now, the test which the honorable courts, even this is a writ petition that the participants are going to argue, and for all the judges who are to judge the competition, the very point of determination of who is the best among the best would be the thin line of difference that they would be casting between what is obscenity and what is protected between 19(1)(a) and not being barred by 19(2) or 19(6). Hicklin test was one such test where the Canadian Supreme Court went on to formulate guidelines as to what parameters must be determined to classify a particular act to be obscene or to not be obscene. Avik Sarkar versus the state of West Bengal. The Indian Supreme Court deviated from the Hicklin test, and we got formulated the community standard test. Now, as recently as 2023, I do not know how many of you know about it, but this is a judgment by the Kerala High Court. It is referred as XXX versus the state of Kerala, where the Honorable High Court has further gone to analyze the community standard test, placing reliance on one of the later judgments by the US Supreme Court in R versus Butler, and has come down to fine-tune the meaning of obscenity and to classify whether the offense being so alleged to be an offense falls within the domain and category of inciting an act of obscenity amongst the public at large. I wish all the participants a lot of luck. I want you to analyze the precedents while you argue. For that, these are the years when you can fine-tune your arguing skills by being part of these competitions which not only recognize your hard work and potential, but also provide you a platform to read and work upon laws which are usually not covered in our course curriculum. Because I'm sure obscenity versus 19(1)(a) is not being taught in law schools. Another thing is that the community as a whole has grown from the time these tests have been propounded. From 1868, we came down to 1892, to 1902, to 1929. These tests have gone a repetitive revolution every time they have been brought under a judicial scrutiny, be it in any constitutional code of any country. Standing as of 2024, if Ranjit D. Udeshi precedent is to be considered, it holds no value as of today. Because Ranjit D. Udeshi verbatim followed the Hicklin test. And Hicklin test in Avik Sarkar was done away with. So please, when you argue, when you present your petition or you oppose that petition before the honorable judges who are to judge this competition, I want you to think from your heart, speak from your mind, and stand in the shoes of either the petitioner or the respondent when you are going to do so. कहते हैं दिल से हारा हुआ केस भी अगर करो तो जीत जाते. एटलीस्ट ये मैंने सीखा है, मैंने संजय सर को देख के ये सीखा है दिल्ली हाईकोर्ट. सो आप सबको ढेर सारी शुभकामनाएं, ढेर सारा प्यार. और कौन कहता है यारो कि आसमां में सुराख नहीं हो सकता, आप सबसे एक रिक्वेस्ट है कि एक पत्थर तो तबीयत से इस बार उछालिए. Thank you so much for having me. Thank you so much to consider me a part of this August gathering and to make me sit in front of my idols whom I have learned litigation from. आभारी हूँ. सांखला साहब, ये जो इनिशिएटिव है सर, this is tremendous, and sir, this has to go for editions. ये हम सब में, हम बहुत वकील हैं सर, हम करोड़ों में हैं इस देश में. ये सोचने वाले भी आप अकेले ही थे, ये करने वाले भी आप अकेले ही थे. थैंक यू. आभारी सर.
Very beautifully said. Thank you.
Thank you so much, Abhinav sir. Your esteemed insights and words of encouragement have surely seemed to motivate all of the participants here today. Now, it is my distinct pleasure to introduce our guest of honor, Mr. Sanjoy Ghose, a distinguished senior advocate at the Supreme Court of India. Mr. Ghose has an illustrious career marked by significant roles, including serving as the additional standing counsel for the government of NCT of Delhi from 2015 to 2021 and as the standing counsel for the Delhi High Court from 2013 to 2021. His dedication to the legal field is further highlighted by his tenure as a member of the Delhi State Legal Services Authority from 2011 to 2013. In addition to his national contributions, Mr. Ghose has made notable international impacts as a consultant for the International Labour Organization in 2003 to 2004, where he drafted a crucial bench manual for industrial adjudicators, which was circulated by the Ministry of Labour, Government of India. He has been a resource person for sensitization workshops since 2016, sharing his expertise at the Delhi Judicial Academy, V.V. Giri National Labour Institute, Miranda House, Delhi University, and the National University of Study and Research in Law, Ranchi. Mr. Ghosh, a 1996 graduate of the National Law School of India University, Bangalore, where he was a university third rank holder, he has also contributed significantly to legal practice through his role on the Delhi High Court appointed committee, where he scrutinized and settled claims of secured creditors and workmen in various companies under liquidation. His global engagement includes participating in the conference of the International Bar Association in London in 2001 and representing the Ford Foundation at the International Conference on Access to Justice in New York in 2000. Please join me in warmly welcoming Mr. Sanjoy Ghosh.
Thank you. Am I audible?
Yes, sir. Now I'm pleased to invite Sir to share a few words with us. Over to you, sir.
So, you had you had a very, very academic and a scholastic introduction by Kapil, and you had a very, very practical introduction by Abhinav. After that, I really marrying practice and the academics. You have the perfect prep up for your moot court. So I really don't know what much I can add. But I can tell you that what you see, the counsels, the three of us, we are all practicing law in the Delhi High Court, mostly. And we may have fought against each other. But you will see that this fight is only in the courts. The legal community is such a close-knit community. And outside court, you will find that people who fight so viciously, so vigorously, are the best of friends. They'll fight in court and they'll go to the canteen and they'll be having a samosa or chai together. So what is the most important thing that you learn even in your moot court is that you are not here as enemies. You are here as friends. You're doing a job. Your job is to win. But remember that, and I'm sure Abhinav and Kapil have the same experience, some of our greatest friends from the bar are the people we fought the most with in court, our opponents. Because they see, okay, this fellow is a fair fellow or this fellow is a good fellow, and then they become friends. So for all you know, your opponents in this moot court competition will one day be your friends, your best friends. Now, I used to be very scared in law school about moot courts. I used to find that, it's very tedious and it's very serious, and I was not a serious person in law school. So I avoided doing moot courts until the fourth year. And then fourth year, I said, you can't finish law school without trying moot court even once. So I as a matter of fun, or at least CV mein aana chahiye ek moot court to kiya, I did it. And again, it's destiny. As luck would have it, our team qualified and we went to the national selections in Jessup, in Madras from Bangalore. And as luck would have it, we topped the national selections and we got a free trip to the US to participate in the Jessup International Law Moot Court competition. But then, of course, we didn't score, we didn't win the competition. But it was a good experience. But I said that is enough. And then that one experience in Moot was enough for me. I said, then it's too serious, too hardworking. But I am not saying follow my example. And don't be lazy as I was in law school, because what you do in moot courts actually trains you and skill builds you for the real profession. A lot of people have all these things going about law. Law is a jealous mistress, this, that. But the fact of the matter is, there's one saying which has really stuck to me, and which is, who says law is a bed of roses? It's either beds or it's roses, which means that it's either you are working so hard, you have no time for the bed to sleep, and then you have the roses, or it's only beds that you're sleeping and you won't get the roses. Well, it need not be like that. And as Abhinav told you, the High Court now is trying to encourage lawyers to also be humorous. You have now a humor section involved. The point which I am trying to make, I don't know whether I'm communicating to you all, is that in addition to working hard in your moot courts, it's very important to keep in mind the spirit behind all this. Why is it that Kapil, Abhinav, all of them have invested their time and their money, which is more important? Many people can say many things, but here's someone who's showing their commitment. It is because it is important to invest in the future of the bar. You students are the future of the bar. And then the bar is the mother of the bench. And Judge Saab is sitting over there. So it's from the bar that ultimately the bench will come. And it is very important to have not only competent people, but to also have fearless people who will be students, who will then be in the bar, and ultimately who will then adorn and grace our benches, the bench, the court. So you are the future. I mean, let's be very clear. Abhinav and Kapil are investing in the future. And I can't think of a greater investment and a wiser investment than this. So I wish all of you the very best. I know that these talks can be, drag on a lot. So I end here by just wishing you all the best. And keep in mind that you are in very, very lucky and unlucky times. Lucky, as I say, is because as Kapil pointed out, that we live in the age of video conferencing. We live in the age of technology. Today, you guys are seeing Constitution Bench proceedings live, and you are seeing the argument skills. Imagine if Keshwananda Bharati was also video conferenced, or if there was even a video recording of Keshwananda Bharati, or Menaka Gandhi, or even some of the great cases that we just talked about, Ranjit Udeshi. If the law students of those times, if even us in the 90s, we are of the 90s, if we had the opportunity that you people have, that you guys have. And I say negative also because at one level, there is such a pressure on you people to perform, to achieve, which also is wrong. Law is, especially litigation, requires a great gestation period. You must have patience. And I want to end with this, though this is not relevant, but one of the law students just took her life in the NLU. You're young students, and I want to end by this. Please don't pressurize. I know it's easy for me to say, but please don't pressurize yourself like this. Kapil and Abhinav will tell you that while I'm going to tell you a very politically incorrect thing, and Judge Saab will also maybe throw his wisdom on this, but remember that many of the people who are toppers in your colleges today may not be the toppers in the fight of life. And many of you who may think that you have missed the train, that you missed the bus, you will surprise people by outshining everyone. Life is very, very different, and it's a long race. So whether you win or lose the Moot, whether you win or lose in an examination, please don't be despondent. You have many people in the bar. You have two of them in the screen right now who are mentors who you can reach out to. Speak to them. Seek guidance. Reach out if you feel despondent. Please, life is very precious. And please don't let anything get to you. So all the best. I think I've spoken more than I should. Thank you so much. All the best.
Thank you so much, Sanjoy sir, for such an engaging and dynamic speech. Your active participation and thought-provoking insights have greatly enriched our event and provided us with much to reflect upon. Now, it is my profound honor to introduce our chief guest of the day, Justice Mahendra Dayal, who has previously served as a judge of Allahabad High Court. Justice Dayal embarked on his legal journey with a law degree from Allahabad University in 1978. He was enrolled as an advocate on January 4, 1980, and began his practice with a focus on both civil and criminal matters. His career in the judiciary began in 1996 when he was appointed to the Higher Judicial Service, and he was subsequently promoted to the position of District and Sessions Judge in 2007. On April 17, 2012, Justice Dayal has elevated to the bench of Additional Judge of the Allahabad High Court, and he took the oath as a permanent judge on September 5, 2013. Throughout his tenure, Justice Dayal has been known for his profound legal acumen and unwavering commitment to justice. His distinguished career has been marked by the thoughtful adjudications and a deep dedication to the principles of fairness and integrity. His judgments have not only shaped the jurisprudence of the Allahabad High Court, but have also made a significant impact on the broader legal community. We are deeply honored to have Justice Mahendra Dayal with us today. His presence enriches this competition and serves as a beacon of inspiration for all the participants. We look forward to the insights and wisdom he will share, which will undoubtedly enhance our understanding of the law and its practice. Please join me in extending a warm welcome to Justice Mahendra Dayal. Now, I'm pleased to invite Justice Dayal to share a few words with us. Over to you.
Thank you. Thank you very much. Respected Mr. Kapil Sankhla ji, Patron-in-chief and managing partner of Sankhla Associates, Mr. Anubhav Mishra, and Mr. Sanjoy Ghose, Senior Advocate, Supreme Court of India. As I was introduced that I passed out in the year 1978, and thereafter I started my legal profession, entered into the legal profession in the year 1980. In my days, when I was pursuing law course in Allahabad University, there was no concept of this moot court competitions. And it is now the privilege of all the law students to have such facilities all over the world, not only in India, but almost all the universities and institutions are organizing such types of moot court competitions. I'm privileged and honored to be the chief guest in this third National Moot Court competition organized by Amikus Qriae and Sankhla Associates. Let us first see as to what is the concept of moot court. Moot court is a simulated court proceeding organized by law universities, law colleges, institutes, and other organizations in which law students take part to learn the court proceedings and the procedure adopted for conduct of cases. In our days, there was no such concept anywhere, and the law students used to learn about the proceedings of the court only when they used to enter the legal profession. But now the time has changed, and such types of activities are included in the curriculum of various law institutions, and the students get opportunity to know as to how the court actually works, and this helps them a lot in profession and judicial service as well. When I entered into legal profession, I found the working of the court entirely different from what I studied in the university. And it took a lot of time to be acquainted with the working and procedure because it was never taught to us in the classes. You all are lucky enough to have such activities almost everywhere and get a chance to improve your skill. Mooting actually enables the students to engage with and think deeply about the topical legal issues to enhance their advocacy, legal research, and writing skills to work closely and demonstrate their competence as an advocate. It also helps in building confidence. In present days, hundreds of law students are produced by various law universities, colleges, and other institutes. This has increased competition amongst the law graduates in every field. Moot court is therefore essential for law students because it develops skills and qualities that will prepare them for their future careers. If you join legal profession, you need speaking skill because you have to appear in the court on behalf of your client and present his case to impress upon the judge. This is called oral advocacy. And to become a good lawyer, you are required to argue your case in such a way that the judge is impressed and passes order in your favor. As a lawyer, you need critical thinking to understand the problem of your client who approaches you for the redressal of his grievance. You also need to have ability to solve the problem of your client, and for this, you must analyze the issue in a legal manner and make effective arguments before the court. The moot court proceedings help you in developing these skills. Many of you will join legal profession after graduation. Some of you may join judicial service or may work with law firms or may work anywhere. But wherever you work, your skill of critical thinking and writing will help you. Mr. Sankhla has spoken about the right of freedom. The freedom of speech is one of the fundamental rights guaranteed by our Constitution of India. But what I personally feel that this freedom of speech and expression must have certain restrictions because in recent years, we have seen that this freedom of speech and expression is being misused by certain people, and because the freedom of speech does not authorize you to defame anyone or to malign the prestige of anyone. So there has to be certain restriction. So far as the obscenity is concerned, obscenity has different meaning, and it is it depends upon the judge as to what in his opinion is obscene and is not, and what is not. In India, as we see that kissing in public place is supposed to be the obscene work, obscene act, because our society does not recognize it. But in foreign countries, the kissing at public place is not supposed to be an obscenity. So in our country and in our society, the obscenity has a different meaning. But yes, certain high courts and even the Supreme Court has defined as to what the obscenity is and what should be the freedom of speech. What are the boundaries of freedom of speech? So I wish all the participants in this moot court competition to do well, present your case well, and I wish all the success to everyone. Thank you very much.
Thank you to Justice Dayal for his insightful speech. Hearing from him was surely an enlightening experience for all of us. As we conclude today's event, I would like to extend our heartfelt gratitude to our chief guest, Honorable Justice Dayal, for sharing his valuable insights and enriching our program with his presence. His stimulating words of encouragement have made this occasion truly memorable. We offer our sincere thanks to our esteemed guests of honor, Mr. Sanjoy Ghose and Mr. Abhinav Mishra, whose participation and support have added immense value to our event. A special thank you to our Patron-in-chief, Mr. Kapil Sankhla, for your unwavering support and guidance. Your leadership and dedication have been instrumental in the success of today's gathering. My immense gratitude to our esteemed sponsors, Chambers of Abhinav Mishra and Sankhla Associates. We also want to thank Professor Kuldeep Berwa and team for drafting the Moot proposition. Also a thank you to all the knowledge partners, media partners and support partners. Additionally, I would like to express our deep appreciation to Mr. Rupam Banerjee, founder of the Amikus Qriae and the organizing team of Amikus Qriae, for the exceptional effort and dedication in organizing this event. Your hard work behind the scenes has ensured everything ran smoothly. A huge shout out to all our participants. We wish you the very best of luck in your endeavors. May you continue to achieve great success and make a positive impact. Thank you all once again for being with us and making this event a remarkable success.
Thank you very much.
Thank you so much, sir, for joining.
Participants can continue to leave the meeting, and further additional information would be shared in the WhatsApp groups. Thank you.